Yes.
Are they going to continue to read the published document for a bit?
Yes.
Is it permissible if Mr. Ormer and I step out while that happens without disrespecting the court and have a conversation about some stuff?
Yes.
Oh.
I have a note from a juror that says, at least in the quiet room, 5 jurors, we are agreeable to having a short lunch or working late to keep on schedule. So, okay. Let's bring him back, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Right before the break, folks, we had distributed a couple of exhibits or copies of them so that each of you can review them to expedite the publication of the exhibits. We're going to distribute those copies to you again and give you some time to review them. I wanted to let you know that we're still ahead of schedule, a little bit ahead of schedule, so we're good. Thank you. I hope to keep it that way. All right? Thank you. All right, Ms. Gerlings and Ms. Robinson, if you would distribute the copies of the 2 exhibits, please. While the jury is doing that, would Ms. Teach McGuire and Ms. Spengler please approach? Mr. Edson or Ms. Teach McGuire, could you let Mr. Brockler know that I need to speak with him and Ms. Hicks for a moment, please? Counsel, please approach Mr. Brockler and Ms. Hicks. Oh, Mr. Brockler, you left one here. I forgot to give this back to you. While the jury is reviewing those exhibits, would Mr. Edson and Ms. Spengler please approach? Folks, does that noise bother you, or is it okay if we do some work while you're doing some work? Yeah, okay, great, thank you. I ask if that noise bothers you about 2 months into the trial. Members of the jury, I know I gave you these two instructions yesterday, but with respect to these exhibits, please remember that it has been admitted with redactions, and you are not to draw any inferences from the redactions. And then the other instruction is that any statements in those exhibits that you're reviewing that are not, that were made by someone other than the defendant have been admitted only for the limited purpose of placing the defendant's statements in context and making them intelligible. And you are not to consider those statements for any other purpose. I just wanted to remind you about that. Does everybody understand that? And everyone's saying yes. Thank you. All right, the record should reflect that we just finished publishing the two exhibits I mentioned a moment ago, one for the prosecution and one for the defense. So at this time, you may call your next witness, please.
You know, the people call Fran Osterberg?
Good morning.
Good morning.
Could I have you raise your right hand for me so that I can administer an oath, please? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. Please tell us your full name and spell your first, middle, and last names.
Frances Marie Osterberg. Frances, F-R-A-N-C-E-S. Marie, M-A-R-I-E, Osterberg, O-S-T-E-R-B-E-R-G.
Mr. Brockler, you may proceed.
Thank you, Your Honor. Ma'am, would you please tell us what you do for a living?
I'm the Assistant Dean of the University of Colorado Anschutz Medical Campus in the graduate school.
Do you have a pretty full understanding of the administrative aspects of the graduate program that would have included the defendant from back in 2011 and 2012?
I do.
Do you also have certain responsibilities regarding records that are maintained about students in the graduate school program?
Yes.
Your Honor, may I approach the witness?
You may.
Ma'am, I'm handing you what has been previously marked as People's Exhibits 1254A, 1254B, 1255, and 1054. Can you take a look at those and tell me if you recognize what they are, and then we'll go through number by number and you can describe for us what they are, okay?
Okay.
Your Honor, we don't have any objection to the admission of these records.
All right, thank you. Mr. Brockler, are you intending to move into evidence these four exhibits?
I am, and I'm
All right.
excited.
Without objection, they are all admitted and they may be published.
Ma'am, could I, just for the record, so that it's clear, Judge, can I have her describe what each document is going through the exhibit numbers now that they've been admitted?
Yes?
Ma'am, would you just go through the ones top down and tell us by number, and just like 1254A is, and tell us what it is?
Okay. 1254A is a transcript from the University of California, Riverside. So this is the official transcript for Mr. Holmes that was received from the University of California, Riverside and directly from the University of California, Riverside to the University of Colorado to be part of his academic record.
Thank you. And can you tell us what the next exhibit is?
So 1254B is his GRE scores. This would have been received directly from ETS, the Educational Testing Service. And as I said, these are his official GRE scores.
Okay.
That again would have become part of his academic record.
Thank you. And the next one?
1255.
Yes, ma'am.
Okay. 1255 is his petition for in-state residency. So after he has been a student generally most of our students are out-of-state students, not all of them, but a large number of them are out-of-state students. So after they've been a resident of the state of Colorado for a year, they petition to become an in-state resident. So they have to complete this particular form to petition to become an in-state resident and then be reclassified as an in-state resident. So that's what this form is. And so he's then been declared as a resident.
I'm sorry, I was going to ask a couple questions about that.
I apologize.
No, my fault. First off, can I get you to bend that microphone just a little bit down more towards you? Yes, ma'am. Thank you.
Okay.
First off, do you encourage the first-year neuro, psych, or all grad students to apply for in-state tuition?
We do. We tell them a number of times that they need, all the out-of-state students, that they need to immediately upon coming into the state start doing the things possible to become an in-state resident because it has high financial ramifications to the university.
Tell us about that if you know.
Okay, so In these particular programs, all the students are on stipend, and part of that package includes their being able to get their tuition paid for. Well, as they're coming in to be an out-of-state resident, their tuition, obviously with them being an out-of-state tuition, or excuse me, an out-of-state resident, their tuition would be out-of-state. So per Colorado law, they can't establish residency for a year. So we encourage, and more than encourage, we tell them numerous times before they're admitted, again when they're admitted, and again at orientation, that they need to do all the things necessary to become an in-state resident so that a year later they can do this petition to become an in-state resident and then therefore having resident tuition assessed, and then that has financial ramifications to the student if the student is paying their tuition, and therefore to the faculty or to the program if the program is paying the tuition.
So in the case of the defendant, do you know, had he continued on in the program, would he have been responsible for paying that tuition, or is that a benefit to whatever lab would have if they had agreed to take him to their bottom line on what they pay?
In his particular case, he was in a program where the program or the new PI, the lab that he moved into, would have been paying his tuition. And so it would have been a benefit to the program or to the PI that the tuition dropped from out-of-state tuition to in-state tuition.
Now, you told us that you repeatedly encourage the first-year students to pursue this in order to save money for themselves and the university. Does every first-year grad student that's out-of-state initially do exactly what the defendant here did with this paperwork?
That's correct.
Take a look at it real quick, and I want to tell you, in the upper right-hand corner, there's a handwritten sort of coding that includes maybe a handwritten date. Do you recognize the initials of who did that?
Yes, I do.
Who is that?
This is Diana Warren, who's a staff member in the registrar's office.
Now, she has written some voodoo-like code up there that includes a date of 3-9-12. Do you see that?
Right, I do.
Does that appear to you to be just a clerical error?
Yes, she's written on here the res, which means he's been declared a resident, and then the date. But if you look further in the document is dated in April of 12, so she couldn't have dated that she's declaring he's a resident in March of 12. So it's obviously just got to be a clerical error.
In fact, what you're referring to in the application is a notarized signature of the defendant dated 4/9/12. Is that correct?
That's correct, and it's again notarized by Leah, who I also know, and so I'm assuming, I know Leah, but that he dated or she dated it in his presence in April.
There are two other documents that are contained within that exhibit that are tax returns, one from Colorado, most recently filed by the defendant, and one from California, also recently filed by the defendant. Is that fair?
I see the Colorado. Just a second. I see the California, yes.
Okay. And before I move off of that document, you had mentioned something about a stipend. Do you know how much the defendant's stipend would have been, or was there a common amount?
There was a common amount across all the PhDs. I'd have to go back and look at the records for that particular year. I can tell you what it is this year, but I just don't remember back in that year what it was. It was probably $2,000 or $1,500 less than it is this year.
Okay. Well, and just so that
this
we're all
year
clear.
It's $28,500.
Okay, thank you for that. And so that we're clear, though, you're speculating somewhat based on what you know about how the program has changed over the last several years in terms of the stipend?
Yes.
Okay, thank you. There's one more document that's included up there that was admitted. That's 1054.
Yes.
You know what that is?
So this particular document is his official CU transcript with a recording of his grades for the fall 11 and spring 12 semesters.
And are those the only grades and the final grades that the defendant had earned at the conclusion of his first year of grad school?
Yes, they are.
You don't have any other grades for him?
There are no other grades.
Your Honor, I don't have any further questions. Thank you.
That last exhibit is P-TR-1054, correct?
Yes, sir.
Okay. Is there any cross-examination, Ms. Higgs?
I have, okay, maybe 3 questions. On that document about the in-state residency, you were indicating that the date on the front of that, when it would have been approved, that date says March 9th of 2012.
Yes.
And the actual application was signed on April 9th of 2012?
Yes.
So you're indicating it's just likely somebody miswrote.
Yes,
The
it has
month.
to be a clerical error.
Right, right. No, I don't have any other questions for you, thank you.
Okay.
And the jury does not appear to have any questions. You don't have any redirect, right, Mr. Brockler?
No, sir, I don't.
All right, is there any objection to releasing this witness?
No, Your Honor.
Your Honor.
All right, thank you. You can give me those.
Okay.
Thank you. Hey, Connie.
Thank you.
Call your next witness, please.
Your Honor, the people call Tom Triska.
Solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. I do, Your Honor. All right, please be seated. Could you please tell us your full name for the record and spell your first, middle, and last names?
First name is Thomas, Thomas. Middle is Bennett, Bennett. Last is Triska, Triska.
Mr. Brockler, you may proceed.
Thank you, Your Honor. Sir, it's going to sound silly based on how you're dressed compared to everyone else, but what do you do for a living?
I'm a deputy sheriff with Arapahoe County
How long have you been doing that?
since 1995.
On September 20th, 2012, were you assigned to move the defendant from the jail to courthouse number 2?
Yes, sir.
Was that for purposes of a court appearance in front of a different judge who has since retired?
Yes, sir.
Now, tell us, do you remember what time that court appearance was, roughly?
I believe the court appearance was 8:30, 9 o'clock.
What time then, in that case, do you and any other deputies move the defendant over to the courthouse?
On that particular day, 5:15-ish, I think, is about when we moved him from the jail over to courthouse 2.
Now, when you moved him over to the jail back on September 20th, 2012, do you just sit with him in the courtroom until the court calls the case, or does he stay somewhere else?
Deputy, could you move the microphone closer to your
Sure.
mouth, please? Thank you.
Once we have him over to courthouse 2, we will take him up to the second floor and we put him in a whole cell, basically on his own, until the court proceeding would go forth at 8:30, 9 o'clock.
And did you do that with the defendant on September 20th?
We did.
And how long would he have been in that cell?
In that particular cell on that day, I'm going to say 2.5 to 3 hours before the hearing actually took place.
Now tell us, once he's in the cell, is he further shackled in any way, or is he free to move about?
When we initially take him over, we'll place leg restraints on him, and then we'll place a body belt around him where he's handcuffed, and that's how we'll transport him over. Once we're over to courthouse 2, that is how he remained once we placed him in the whole cell. So he has freedom basically within the whole cell, but he is restrained using those devices.
May I approach the witness, Your Honor?
You may.
I'm handing you, sir, what's been marked as People's Exhibit 1089. Take a look at that and tell us if you know what that is.
I do.
What is that?
It's a DVD of the whole cell on that date in question.
Now, did you have an opportunity to review what's contained on that DVD before you took the stand here today?
Yes, sir.
And do your initials with the date that you reviewed that appear on that disc?
They do.
This is what I want to ask you about it. Now, you said that he had been in that cell for, did you say over 2 hours?
I would say probably 2 to 3 hours he was in the whole cell.
Now, is that entire 2-hour period contained on that DVD?
No, sir.
Which portion of his time in the cell is contained on that DVD?
I would say probably the last 15 to 20 minutes ballpark before we actually were going to go into the courtroom.
Now, let's talk about that. First off, is there a camera in that cell?
There is.
And where is it located?
It's in the upper far right-hand corner of the cell where he is.
And does it just record continuously?
It does.
Now, prior to this portion of the video that we're talking about, did you, once you put the defendant in that cell, shackled the way you described, did you do anything to continue to monitor how he was doing or what he was doing in the cell?
Off and on, We would look in there, if he's making noise, different things like that, we would look in probably every 15, 20, 30 minutes as a baseline, just to observe that, what's going on in there, that he's okay, checking his welfare, that kind of thing.
Tell us about the glass that is on that door that we're going to see in this video. Is that easy to see through both ways?
It's easy for us to see in, but hard for him to see out. There's a window film tint on the outside of it, so it's a little harder for him to see out, but it's fine for us to see in.
For someone who wanted to see out that window, how would they have to position themselves in terms of nearness to that window to see out?
You would basically have to walk up pretty much close to the door and kind of put your hands, on the side of your face to kind of shield the light from the outside to kind of look out and see what's going on outside of the cell.
If you did that, could you see what was going on outside in the hallway outside the cell?
Yes.
Okay, this particular segment, are we going to see you in some portion of this segment?
Yes, sir.
Tell us about that. What part do we see you at?
You'll see me once I open up the cell, and that's when I'm going to tell the defendant it's time we're going to go to court. And so when the cell door is open, that will be me standing in basically the frame of the door, telling him to come out. We're ready to go into the courtroom.
Now, is there another deputy that becomes visible on that video?
There is. It'll be just to my right-hand side once the door is open.
And who's that?
That's Deputy Mike Mead.
And do his initials appear on that DVD as well?
They do.
Now, this particular video, are you watching it while it's happening?
When we're going to pull him out? No.
So did you have an opportunity to watch this video shortly after this thing that's captured on it?
Yes, sir.
And does it appear to you, other than not covering the entire 2 hours before this, to be unedited in terms of what took place from the last time you checked on the defendant up until when you see yourself pulling him out of the cell?
Correct.
Your Honor, I'm going to move for the admission of People's Exhibit 1089. Is that what it says, sir?
Is there any objection,
I don't see it
any
on there.
additional objection to P-TR-1089?
No additional objection, but we'd renew all of our previously stated objections.
All right. Based on my previous rulings, the exhibit is admitted. That's P-TR-1089, and it may be published. I say rulings, it's one ruling, but I have addressed it at different points throughout the proceedings.
Can I retrieve the DVD?
Yes.
As I'm doing this, Deputy, I do have a question. I said, because I know what it is, Courthouse 2. First off, tell us where we're at right now.
We're in Courthouse 1 now.
And where's Courthouse 2?
Courthouse 2 is just right across the courtyard.
Do you want me to dim the lights, Mr.
Yes,
Rucker?
yes, sir, please.
And there's no sound in this, correct?
Yeah. Okay, I've been told there's no sound. And it's about 11 minutes long, sir.
All right, thank you. Oh, and before you play, can you stop for just a moment, please? I'm sorry. Members of the jury, I need to give you an instruction with respect to this testimony and with respect to this exhibit, so I'm going to give it to you now before the video plays, okay? The court has admitted this evidence, including the testimony of Deputy Triska, as well as this videotape, People's Exhibit P-TR-1089, for a limited purpose. You may consider this evidence only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. I have explained to you before that when I refer to the issues raised by the defendant's plea of not guilty by reason of insanity, I mean issues related to the following two questions. Number one, whether the defendant was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. And number two, whether the defendant suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charged. And I've also explained to you that each crime charge in this case has elements, and I have given you those elements in the past, and I will give them to you again. One of the elements for each and every crime charge in this case is sanity. That is to say, the prosecution has to prove beyond a reasonable doubt that the defendant was not insane at the time of the commission of the act. That's one of the elements the prosecution has to prove beyond a reasonable doubt with respect to each and every crime charge in this case. The evidence that I just mentioned a moment ago, Deputy Triska's testimony and this particular exhibit, Exhibit P-TR-1089, has been admitted only with respect to the element of sanity. And you cannot consider it with respect to any other element of any crime charged. You can only consider it for the limited purpose for which I have admitted the evidence. Does everyone understand that? Yes. And everyone's saying that yes and not in their head yes. All right. Is there any additional instruction that the people or the defense is asking me to give at this time? Mr. Brockler?
Not from the people, Your Honor.
Mr. King?
No, Your Honor.
All right. Thank you. All right. You may now play the exhibit.
May I ask one question, too, to just set this up before we press play?
Okay.
Deputy, this is about 11 minutes long. Is that fair?
Yes, sir.
The portion that involves the activity for which we're admitting this, that doesn't take place for several minutes into this, is that right?
Correct.
Okay, thank you.
Okay, the records reflect that the people just finished playing Exhibit P-TR-1089.
Couple quick questions to follow up. When we saw the defendant standing right up by the door in front of that window, from your experience with these cells, could he have seen out into the hallway and seen what you, Deputy Meade, anybody else was doing out there?
Yes, sir.
In terms of the way he was positioned, his back appeared to the window. If you had looked in, would you have been able to see exactly what he was doing?
No.
That camera that's mounted up in the corner that recorded this, is that camera monitored?
No.
It just records unless something
Words
happens.
and, correct.
Now, I don't want you to speculate as to the meaning behind it all, but when you opened that door and you saw the defendant, first tell us what he was doing with his hands in that chain.
I opened up the door. I told Mr. Holmes it's time to come out. We're going to go to court. And he had a smirk on his face, and he had the...
Judge, I'm going to object to the characterization. May we approach?
Yes. All right, members of the jury, the objection is sustained, and the answer is stricken. And so you should disregard both the question and the answer. You should treat the question and answer as though you never heard them, okay? Mr. Brockler, you may proceed.
Deputy, with regard to that camera that we talked about that's having the unmonitored recording that's going on, do you remember that?
I do.
Is it hidden in any way, or is it pretty obvious when you look up in the corner that that is going to be a video camera?
It's very obvious it's a video camera.
I have no further questions, Your Honor.
All right, Mr. King, do you have any cross-examination?
May I have a moment, Judge?
Yes?
Questions.
Okay, you may proceed.
Deputy, I think you said that was September 20th was a day that we had court around 8:30, 9 o'clock in the morning. Is that right?
Correct.
So you said you brought Mr. Holmes to that cell 5 o'clock, 5:30 in the morning, correct?
Approximately, yes.
And I think you said this, but when we are watching that segment of the video, he's been in that cell for nearly 3 hours at that point. Is that right?
Correct.
And we don't know what, none of that was preserved. None of the videotape was preserved of what happened or what he was doing previous to the segment that we've seen in court. Is that right?
Not that I've ever observed.
And during that period of time, he's not allowed anything in that room. I think he got breakfast in that room that morning, did he not?
Correct, a sack lunch.
Other than the sack lunch that he got, he's not allowed to have books in there or newspaper or reading materials or really anything else. Is that right?
That's correct.
He's just sitting in there waiting for you to come and tell him when it's time for court.
Yes, sir.
You may.
That's all I have.
Thank you.
All right, do you have any redirect, Mr. Brockler?
I do not, Your Honor. Thank you.
All right. And the jury does not appear to have any questions for Deputy Triska. May Deputy Triska be released from his subpoena?
Yes, sir.
And Mr. King, do you want to release him from his subpoena, or do you want him to be subject to being called again?
I think Deputy Triska might like to be released, but I'm going to ask that he remain under subpoena.
All right. Deputy, you will remain under subpoena, and you're subject to being called again, okay?
Yes, sir. Thank
All
you,
right,
Judge.
Thank you. Would counsel please approach to talk about scheduling? All right, members of the jury, sorry, Connie. It's 10 after 12 or 12 after 12. So we're going to go ahead and take our lunch break. Let's take the usual hour and a half, and then let's make sure that you follow all the advisements that I have been giving you. All of them apply during the break, and all of them are mandatory, as you know. I'll see you back here in an hour and a half, okay? Thank you. Enjoy your lunch. The record should reflect that the jury has exited the courtroom. Please be seated, everyone. Is there anything we need to talk about at this time on behalf of the people? Yes.
And while Mr. Orman's doing that, I do have one thing.
All right, Ms. Penguin?
Judge, I failed to make a foundation and authentication objection to the Hotmail exhibit that we spoke about earlier. It dawned on me that I don't need to wait until Agent Phelps takes the witness stand because the district attorney, as the court may recall earlier this week, brought in a custodian of records but did not move to admit the exhibit. So the objection was not ripe, but since I believe the district attorney will attempt to introduce the Hotmails, I just have a brief record to make regarding our position on foundation and authentication. I don't know when the court wants to hear that.
Okay, yes, please.
Judge, just briefly, we don't believe that the proper foundation was laid by the witness from Microsoft earlier this week. Specifically, if the district attorney, and it appears through their questioning, they're attempting to introduce these Hotmail or lay a foundation through the business records exception. And I would specifically note that the testimony was lacking in terms of whether or not Microsoft, whether the information is provided as part of a business relationship between a business and an outsider, and there is evidence that the business substantially relied upon the information contained in the records. And regarding authentication, Your Honor, I would just note that there was a request made to Hotmail by law enforcement. That came out as evidence through the testimony. They were specifically looking for the D. Sherlock B. Hotmail records contained by the Microsoft organization. Those records were returned. But in terms of identity, in the characteristics or the characteristics within the email that establishes identity or the corroborating circumstances, I would just argue that that is lacking. There is no admission here, admission here by Mr. Holmes stating that that is his email address, and we kind of have a domino effect with these different email accounts, and I think they're being layered on to sort of establish identity, and I just wanted to note that authentication objection as well. I'd make these arguments and note that this objection is pursuant to Mr. Holmes' due process rights, right to a fair trial, as well as right to confrontation of the Colorado and United States constitutions.
All right, Mr. Edson, it sounds like there are two additional objections, although one of them comes within the hearsay objection previously articulated. The argument is that if you're going to attempt to introduce these documents through the business records exception, that not enough foundation has been established. And if you're not intending to do that, then maybe that's not an issue. But the other one has to do with authentication, and specifically with the second requirement under People versus Glover, and that is 2015 Westlaw 795690, Colorado Court of Appeals case from 2015.
Sure, Judge. As the court knows, there are essentially two prongs under Glover. I think we've met the first with the testimony from the Microsoft witness on Monday, Christine Cavaleshi. It's spelled K-A-L-A-V-E-S-H-I, and we would move forward under 901B1 as well as 901B4 based upon the testimony therein. As Glover talks about, emails may be authenticated under either 901B1 through the testimony of a witness with knowledge that has matter, that the matter is what it claims to be, or through 901B4 through consideration of the distinctive characteristics shown by an examination of their contents and substance in light of the circumstances of this case. So, Judge, we believe that we've met that particular aspect of People versus Glover. As to prong 2, the emails are linked to the defendant's account. We know that Glover requests additional corroborating evidence of authorship in order to move forward under the foundation authentication. Judge, we would note this is really the third set of emails now that the court has entertained this type of argument related thereto. We just need to show, as Glover talks about, this is not a fictitious email account, and it's not pursuant to the testimony of the Microsoft witness earlier this week, but specifically that this is not somehow another individual using Mr. Holmes' name for this particular account. So the corroborating evidence here is substantial, Your Honor. First of all, this particular email address, the dsherlockb@hotmail.com, has been used by numerous transactions that the court has heard extensive testimony related to. Many of these items were items that were later found either at the apartment or were used in the shooting at the Century 16 Theater. Likewise, Judge, this particular Hotmail account is often used by the defendant towards other counts that the court has already noted are linked to the defendant, including the dsherlockb@gmail.com, as well as the CU email address that the court discussed yesterday. We were planning on asking a question of Special Agent Phelps, but I can give the court an offer of proof on this. There's this particular email. It's the second to last email within the packet of emails from CU. It's dated June 12, 2012. It's an email to Bobo, as the court has heard is the defendant's father. It's the nickname for the defendant's father. And in that particular email, the defendant is giving his father an alternate email address of dsherlockb@hotmail.com. He's doing so with the intention that the CU email address will no longer be working in short amount of time, and giving this alternate email address as dsherlockb@hotmail.com. So there's a corroborative link in that regard, as well as arguments that were made related to both Gmail and CU. There's numerous writings as to the Goober and Bobo, the signing off as cheers, which are very unique characteristics of them. There's strong connections to the similarities between the writings between Hotmail, Gmail, and CU, including to whom he is writing and or responding to. The people assert that there's sufficient corroboration evidence and sufficient circumstantial evidence to show that the emails are in fact authored by the defendant, not from somebody who made up a fictitious account. We do submit there's more than enough corroborating evidence related to Glover. Related to the hearsay, specifically the people will rely again, as we have in other emails, at the emails that have the defendant responding or otherwise having his text in the email itself for other aspects of email coming from other individuals. They're not being offered for the truth of the matter asserted, but more to put into context the defendant's writings and to making his statements at that particular time intelligible. Judge, if I could have one moment, please.
Yes.
So for those reasons, Judge, we think under Glover we have met the requirements related to these particular emails. If I could have just one more moment, Judge.
Yes.
Judge, the only other thing that I would say is related to the question about the business records. Those questions that were asked of the Microsoft witness all were in Glover. So it's the Glover case that controls this. So that's why some of the foundation that was laid was done so, because of the specific requirements under Glover.
For authentication?
Yes, sir.
All right. Thank you. All right. Anything else before we take our lunch break?
Judge, I have one real quick thing. People's Exhibit, let me backtrack here. For Gander Mountain, back on Monday, the people attempted to introduce People's Exhibit 1100, and I have it in my hand. It's a transaction journal from July 1st, 2012. That exhibit was not admitted, so then we put a CTR 63 and has made it part of the court record. Judge, we intend to call a witness this afternoon from Gander Mountain and may attempt to lay some more foundation for this particular exhibit. And I didn't know if the court had previously addressed a situation where we'd already marked it as a court exhibit, but now want to ask some additional foundational questions to try and actually get it introduced, if we need to remove the court exhibit, or how the court wants to handle that.
we can leave it as a court exhibit, and then just as long as the record is clear that you attempted to introduce it later. And if I introduce it, then it's introduced.
Understood.
If I allow it, I should say, then it's in the record and it's admitted, and there's no harm with having had a previous marking of a trial court exhibit.
Understood. Thank you, Judge.
All right, anything else? No? Okay, enjoy your lunch. I'll see you after lunch. The court will be in recess. Thank you. It's an hour and a half, I said.